I think this is what was said as we want to start.
Yeah. All right. Let's get started. Thank you very much for coming despite this fantastic weather. Yeah, I know that you're tempted to go out and do like all the things people normally do when the weather is so great. Today we have our final guest event organized, hosted by the units, by the International Law and Human Rights Unit. And I'm very, very happy and glad to welcome Paolo Cavaliere from University of Edinburgh, who is going to talk and discuss the issue, very topical issue of fake news. So I will disappear. Magically, yeah. Then we will add some, disappearance tools like
with special effects.
Exactly, special effects.
Well, that's great, and there will be fake news that you just magically disappeared. Well, thank you very much for having me today. It's a pleasure, and I know people are supposed to say it, but it really is on a day like this, and I mean it because it proves my theory that when the English make fun of the Scottish weather, they don't really know what they're talking about because it was sunny when I left from yesterday. So Bonnie Scotland kind of plays in the same league as England really when it comes to the weather. The topic I'm trying to present on today is really pretty much a work in progress. So I also appreciate the opportunity to discuss quite informally. It's a fairly small group. So if you want to contribute with anything, perspectives, questions, please feel free to jump in, because I'm very much happy to keep it as conversational as we can. As I said, this is a topic on which I am working at the minute. It's a project that's been going on for a few months, and it's proven quite challenging because I'm trying to map out different legal or policy approaches to disinformation across different countries, and things keep changing. State legislatures and governments keep changing their approaches and come up with new mechanisms to try and counter the spread of disinformation. So I apologize if there are any inaccuracies in my presentation. I try and stay constantly up to date with things that happen up there, but sometimes it might be that a new and more precise translation of a legal text comes up at a later stage, or there's a few last minute changes, but as far as I know, to my best understanding, this is the current state of the art for today. Perhaps tomorrow something will change already. Since the time when I agreed with Kostya on the topic of this presentation, something has changed already, and the very term fake news is already becoming less and less popular, and there's a growing momentum at the international level for replacing it with the term disinformation. It's a trend that started off, or gained prominence at least, with a report released by the Council of Europe in 2017, with which I'm going to engage in a few minutes, and then the idea of replacing the concept of fake news with that of disinformation has gained more and more popularity, and very, very recently both the UK Parliamentary Committee on Media and Culture have suggested that we stop talking of fake news and we call it disinformation. NATO has also joined the idea, so I will going to engage with the terminology in a few minutes, more at length. Here there's just a selection. There could be perhaps millions is a bit of an overstatement, but thousands of screenshots with tweets, story from news outlets, posts on Facebook that in different ways can be related to the category of fake news. I'm still using the term for now. And you can see how different they are, one from the other. Some of them have gained a lot of popularity and traction during major political events, major political debates, such as the 2016 presidential election in the UK, in the US, or the Brexit referendum in the UK. And here are a couple of examples. The Pizzagate was one of the major topics for discussion during the election debates, and it seems to have contributed significantly to take Hillary Clinton down at the election. Other stories perhaps don't impinge so significantly on political events. There's some celebrity gossip, there's some sensational gossip, and also you can see how if we were to use traditional legal categories to make sense, understand, and operate on these different stories, in many cases, our current legal toolkits would miss a teeth, wouldn't have the possibility to bite. For instance, in a story such as the president candidate at the time, Macron, declares that one of his role models is one of the most internationally renowned dictators. What could we do of it? It's clearly not a case of defamation, as we traditionally mean it. It's clearly not a case of a breach of privacy. It's clearly not a case of hate speech. So in many cases, provided that we want to have legal frameworks to limit the spread of fake news, many of the stories that come out, or also similarly, the Pope declares he's siding with Donald Trump. Is it a case of defamation? Even if it was,
yes.
How likely it is that the Pope sues for defamation? Quite unlikely, isn't it? So in many cases, our current legal provisions miss the teeth to bite on the story that circulate and in some ways pollute our public debate. But even in a broader sense, we could also say, do we need tools to limit the spread of disinformation? Do we want to have legal provisions that tackle news stories such as Macron takes Duterte as a role model? Do we want to take down stories such as Brad Pitt and Angelina Jolie, obviously prior to their divorce, are moving to Kentucky? Do we need to limit the circulation of this content? So this is one of the challenges that lawmakers around the world are facing at the moment. The galaxy of fake news is so widespread, so diverse within the own field, within the realm of fake news, that it's really difficult to A, make sense of what current legal tools can do, B, try and come up with new, more fine-tuned legal tunes that can possibly help to limit the spread of disinformation, but also C, a broader question, if you want. To what extent do we want and do we need to intervene on this new phenomenon? Is it something that is really needed? Or is there the risk that by providing legal measures against this type of phenomenon, we overkill it and we take down perfectly legitimate content? We take down content that didn't need to call for legal action. So I've been trying to somehow reflect on these questions and see in practice how lawmakers around the world are trying to grapple with these questions. I promised you an explanation of why disinformation is replacing at the moment the idea of fake news, and as I said, this comes from the report by the Council of Europe that was released last year and has proven incredibly influential already. The reason why the Council of Europe suggested the replacement is exactly an attempt to shade clarity on this very diverse phenomenon. Research and legal literature in media studies, in political communication studies, up to now, was struggling to grapple with the phenomenon of fake news and make sense of it in a uniform way. So taxonomies of fake news until this very moment included very different ranges of content, ranging from the likes of parody, satire, political slanting, and clearly was using such a broad and all-encompassing, broad brush category proved pretty useless from a legal perspective, because it didn't help to give the concept a uniformity that would allow lawmakers to intervene on it. From a legal perspective, a broad brush categorization is pretty much useless. Also, while the concept of fake news was too broad, the Council of Europe also observed that in other ways wasn't inclusive enough, because it focused on what we traditionally consider as news content, but left out other types of communication that are extremely popular on the web in these days, such as tweets, posts, memes, images, GIFs, and so on and so forth. So, in a sense, too broad in one sense, too narrow in the other. The Council of Europe suggests we replace it with the concept of disinformation, and disinformation is the information that is at the same time false and harmful. The two categories of false information and harmful information already existed in their own right. So we already have examples of information that is false, misleading content, false connection, political slanting in the case of the press, information that is not necessarily true, but at the same not necessarily harmful. Another example could be celebrity gossip, for instance, when it doesn't amount to defamation, when it doesn't harm reputation. So a question in this case could be, do we need to take down information that is false but not harmful? On the other way around, we also have cases of information that could be harmful but perfectly true. Perfectly true, as in the case of leaks, as in the case of confidential information that is leaked to the public. Think of cases such as WikiLeaks, think of cases such as the Panama Papers. Or we can also have information that is harmful, but not necessarily false or true, because it is an opinion. Think of cases such as, for instance, hate speech, racism. And for these categories, more often than not, legal toolkits already provide measures to take down and limit the harm that comes from these types of information. So in this case, we are dealing with some new types of, not new types of information, but it's information that's defined as false and harmful at the same time. The two elements together create this effect of an information that's, that creates some sort of harm. So I will adopt this as an analytical framework, and I will try to investigate in what ways provisions that are being passed at the moment, or that have been passed in the last few years, since the outbursts of this conversation on fake news or disinformation, the ways in which these legal toolkits engage with the concept of harm, which, again, as I said, it's pretty much fundamental in this conversation. How is the harm defined in legal measures? The report from the Council of Europe also helps to unpack the notion, not just from the perspective of the two pillars, but also in two other different ways. It unpacks the three elements of this information and unpacks the three phases in which this information makes it into the public sphere. These three elements are the agent, the message, and the interpreter. The agent is, of course, the individual or the organization that leads or facilitates the creation, the distribution of the content. So the agent, again, it's the entity that performs the action. In each phase, the agent can be a different figure. The agent that originally creates the message doesn't necessarily have to be the same agent that produces the message. I will explain it more clearly in a few minutes, but it's important to start understanding that there are these three elements in the categorization that the Council of Europe suggests. The message is obviously the content of this information. and the interpreter is the recipient of the message. It's interesting that they use this word interpreter rather than recipient, because it suggests of a more active role the audience plays into this dynamic. And again, I will see a little bit later on in what ways this active role of the audience comes into play. The three phases of this information are instead the creation of the message, the moment in which the message is conceived. The production or reproduction is the moment in which this message is packaged as a news story or as a different format, depending on the way it's then supposed to circulate. So the moment it becomes a news story, the moment it becomes a meme, the moment it becomes a GIF, and so on and so forth. And this can be very much a circular moment, because one of the characteristics of public communication these days is that through the means of the Web 2.0, we, members of the audience, and again we go back to this idea of the active role of the audience, can also repost and contribute to circulate false information. So this phase is called production or reproduction. And finally, there is the moment of the distribution. Distribution is when the message makes into the public sphere. Towards the end of of this conversation, I will also go back to this categorization on the element and on the phases to discuss again how lawmakers are engaging with each of these different notions. What is the focus of legislative efforts that are taking place at the moment? Whether lawmakers are trying to focus more on the regulation of each of these phases, whether it's more the creation phase, whether it's more the distribution phase, that seems to be most the center of attention of lawmakers, and also on what type of elements the lawmaking activity is focusing most clearly. So we'll go back to these later on in this presentation, but I just wanted to clarify that these analysis of this information coming from the Council of Europe pretty much provides an analytical framework which I'm using to analyze the different efforts made by state legislatures from a comparative perspective. Before having a look at what state legislatures are trying to do at this very time, it can also be helpful to try and engage with a theoretical pre-question, in a sense, because there is one very fundamental tenet of freedom of expression, that the rise of disinformation is somehow challenging. The fundamental tenet I'm talking about is the rationale of freedom of expression based on the idea of the marketplace based on the concept of the marketplace of ideas. This concept, very much Anglo-Saxon / American in its origin, the concept that eventually the truth will emerge from public debate, and that therefore state laws should have no place in deciding what is true, what is false, and should have no place either in taking down content because of its very falsity. This is a theoretical idea, but nonetheless, through the centuries, it's very much shaped the way we regulate speech, even today. Most states, at least in the liberal world, are extremely keen on not using falsity or truthfulness as elements for taking down speech. Because of the legacy of this theoretical position, and also which has shaped an idea, the fear of censorship, the idea that government should play no role in deciding what is true and what is right. Now, the rise of disinformation is somehow challenging this very fundamental tenet that's been with us, as I said, for the best part of the last four centuries? It's challenging it, because this idea that eventually the truth will emerge from the debate, somehow it's proving itself wrong, in a sense. Legal scholars, contemporary legal scholars, concede much more easily than scholars in the past decades that this is a bit of a romantic idea, in a sense. That it presupposes that all those who are engaged in public discourse will be in good faith. It presupposes that the discourse itself takes place on rational basis. It also takes place. It also presupposes that we are comparing opinions. So opinions cannot really be proven false or true. But what happens when it's facts at stake? What happens when the public discourse becomes polluted with false facts? Do they still deserve the same type of protection because of the same very rationale? Some legal scholars think the answer might be no. There is a second and perhaps more contemporary theoretical background to explaining freedom of expression, which sees freedom of the media as an instrument of freedom. The media deserve legal protection, freedom of expression deserves legal protection only in as much as it helps to further the public interest. Only in as much as it helps to bring to the fore points, arguments, facts that help the public debate in meaningful ways. But content that is not meaningful to the public debate doesn't deserve protection. And so it could be taken down without too much worries for respecting fundamental rights. This type of position, to some extent, echoes the American distinction between the scope and the protection of the First Amendment. In the US tradition, there is the idea that we can separate a speech in three different categories. A first category would be any form of speech that are not covered by the First Amendment, and so therefore can be taken down by regulation that only needs to meet a very low threshold of rationality. A typical example is obscenity. Obscene content doesn't further the public interest, and so it's outside of the traditional of the coverage of the First Amendment and can be taken down by regulation that only needs to meet a very low threshold of rationality. Then there's the second category of speech that is covered by the First Amendment, and so can only be taken down by regulation that actually meets very high standards, typically of the same kind of the three-part test from Article 19 in the ICCPR, that laws that take down content, laws that restrict freedom of expression, need to meet requirements of legality, necessity, proportionality, and need to aim to protect one of the aims from the list provided by Article 19. And then there is a third category of speech, and it's covered by the First Amendment and cannot be taken down because of its highest value. If we were to adopt this three-partition, the possibilities that any false speech, so speech that engages with false facts, is even false outside of the coverage of the First Amendment, and so it can be taken down by laws that only need to be rational, but do not need to meet the higher threshold provided by the likes of Article 19. Now, the US Supreme Court has engaged with the idea, with the question of falsity, false speech, in a relatively limited number of cases. And it's also proven somehow inconsistent. It doesn't really seem to take a straightforward, clear direction through the years. But nonetheless, there's a handful of decisions that are very relevant to the case of disinformation as we know it today. The first of these decisions, of course, is New York Times versus Sullivan of 1964, where the court confirmed that false statements are inevitable in the public debate, and so cannot be taken down just because of their falsity, because they are part of the public debate. More recent and perhaps even more relevant is United States versus Alvarez, where the court stressed that false speech laws should still pass the strictest scrutiny, not the lowest threshold, but the strictest scrutiny, because they are covered by the First Amendment. So there is this very explicit statement made by the U.S. Supreme Court, and even false facts are covered by the first amendment. And the government, if needs to take down this type of content, need to prove the harm stemming from those false claims. So this finding from the US Supreme Court brings us back to the analytical framework that the Council of Europe suggested, that in a sense both harm and falsity need to be proven for disinformation laws to be compatible with the international framework for the protection of freedom of expression. The American court has also engaged with the idea of the chilling effect. So there is a strong risk that by taking down content because of its falsity, this stifles the public debate, generating a chilling effect. So this is another reason the US Supreme Court has found to conclude eventually that false facts, false speech is also covered by the First Amendment. In Europe, the tradition is slightly different. We don't engage with this distinction between coverage and protection. The case law of the European Court of Human Rights, as well as the legal literature, engages much more with the idea of different levels of protection depending on the type, on the category of speech. Coverage is a bit outside of our own horizon of conversation, but nonetheless, the European Court of Human Rights in the past has engaged with the idea of the functional protection, the traditional Gersel decision, which says that the media deserve special protection because of its watchdog role, which could be an argument to say the moment the media fail to fulfill this role, doesn't deserve this heightened protection. But nonetheless, it's not as simple. The European Court of Human Rights traditionally, as I said, takes this approach based on the type of, on the category of speech. So political speech is at the very top of this hierarchy and deserves the highest protection. Then one step lower, we have the likes of artistic speech. One step lower again, commercial speech. And then we go down until we find types of speech that do not deserve protection, such as again, obscenity, sexual content, and so on and so forth. It's a spectrum. It's a spectrum in the understanding of the court. And so the way it works is that the highest the category, the more authorities will need to prove a high risk of severe harm for any legal measures that limit speech to be lawful, to be compatible with the protections of Article 19. So if you want to take down political speech, the risk of harm need to be the highest. To take down commercial speech, a lower risk of harm can be enough. Now the difficulty is that most of the disinformation content we are worried about is also political speech in its nature. It's false, for sure, but it engages with problems that are that are of interest to the public sphere. So again, we go back to square one. Lawmakers need to engage with demonstrating what type of harm is at stake in order to lawfully provide for legal frameworks that take down false content. So let's see what are the types of harm that lawmakers are engaging with. This is very small print, first of all, and I apologize. I hope you can see from the bottom of the room. And this is a quite inclusive overview of what different states are trying to do at the moment. A few others are in the process of engaging with bills before the parliament. Some are more likely to be successful and be passed in the next few months. Others seem to be rather doomed, as in the case of an Irish bill, for instance, which is not included here because it's still quite in its early stages and doesn't have the backing of the government, so it's unlikely to become law at any time. But interestingly, it would be quite similar to the French model, which we can discuss in a few minutes. The German example is here in a sense to pay an homage to it, because it's been somehow the not so noble father of many other examples we're going to discuss in the next few minutes. But to a very large extent, this Network Enforcement Act, that is the official name of the German law, it's been touted as a fake news law by many in the media industry, and it's a misnomer. It really is a misnomer, because the German law doesn't engage with the question of falsity or truthfulness in the list. The statute, in fact, references to a list of pre-existing offenses that can be found in the German criminal code already. And what it does is that it creates a new obligation for online platforms to take down content that violates any of the pre-existing laws from the criminal code. Again, the list of possible offenses is very broad-ranging. It includes the likes of treason, distribution of propaganda, private interests such as reputation, violation of privacy, and also more public interest, traditional public interest aims, such as the prevention of violence, crime, and hatred. But again, from the perspective of the legislative technique, this law does not create any new types of offense, and doesn't really engage with the element of truthfulness. And then we have a list of other laws that instead do something different. They do include reflections, or at least they do include the element of falsity in their wording, but also try to identify the risk of harm or the protected interest. Identifying the possible risk or identifying the protected interest really are the two flip sides of the same coin, part of the three-part test. Article 19 of the ICCPR, as I was saying before, I believe we are all familiar with the three-part test from Article 19, but admittedly, the part of the test where the state authorities need to demonstrate that the limitation to speech was in pursuit of one of the legitimate aims listed in the third paragraph of Article 19, traditionally, in practice, does not play the most fundamental role in decision taken by courts. It's rather the element of proportionality that very often is decisive in making this type of assessment. One of the broad-ranging and perhaps long-lasting elements of this conversation on disinformation is becoming prominent in these days is that maybe it's likely to revamp the relevance of the identification of the relevant harm, of the relevant interest. And I will see how different states come up with different identifications of what is the relevant harm or the relevant interest. They take different routes in terms of how they craft the wording of the provision. Some engage with the damage, the harm. Some engage with the flip side, which is directly spelling out what is the relevant interest. The French law is perhaps the most recent in this list. It's a bill that it's being passed as we speak. It received the final vote in the parliament last week or the week before, if I'm not mistaken. And it basically gives a power to public authorities to take down any false content that it's also likely to hamper the fairness of the electoral competition for the 3 months before any election. So it takes this very peculiar path of being both limited in time. It only operates for windows of 3 months before an election, and the harm that it identifies, it's a harm to the fairness of the electoral process. All these laws have raised concerns in different quarters, in civil society, within advocates of freedom of expression, NGOs, and so on and so forth, for being in different ways all somehow at risk of sparking censorship. The case of this French law is now different. It's really attracted a lot of criticism from different quarters. One of the possible reasons of criticism is that, in fact, if we look at Article 19, the fairness of the electoral process is nowhere to be found. And the list of legitimate aims from Article 19 is an exhaustive one. I will come back to this in a few minutes to discuss whether or not fairness of the electoral process can be considered as a legitimate aim under Article 19. But first, we can look at those other provisions that either engage with more traditional aims, although in different ways, or perhaps sometimes just don't engage with any relevant aims, as in the case of the new news aggregators law from Russia. Again, this is a law that's been passed over the last year, and it requires aggregators to check the truthfulness of publicly relevant stories before making them public, and it also gives to the Ministry of Telecommunications the power to order platforms to take down content in case. Yes?
Can I just do two things? Why do you have the slide up? So I don't have to bring you back to it. One is that I'm wondering, just in terms of what's up on the screen and not. For instance, why is the French heading? Why? So, for instance, rules against Holocaust denial. Why would that? Is there a conceptual reason why that's not on your list? It's old, but that's not conceptual. And so, one of my questions is going to be about the temporality of this. Right? And so, I'm wondering if you've thought about that, or if it's just accidental that the Holocaust denial thing isn't there. Similarly, under the South African heading, I'm wondering what laws specifically you have in mind for mental, psychological, physical, and economic, and then why the hate speech stuff, which is people have been prosecuted under, isn't there? Is there a conceptual reason, or is it just an oversight?
Okay, so it's two separate questions, if I understand correctly.
Yeah.
The first was why, in the example of France, we're not discussing Holocaust denial just related to France or in general?
Well, conceptually, I'm trying to figure out what your taxonomy, because that's a key word in your.
Yes, so the taxonomy, so there is a
underlying reason for inclusion. These are just two examples, and I imagine if I looked in a granular way at each jurisdiction, there would be similar questions arising, and I feel like you probably have some conceptual basis for filter.